Music. You know what I mean? Okay, hello everyone. Welcome to Concordia University's Fourth Space. Thank you for joining us for today's event, this afternoon's event. It's a book launch, Family and Justice in the Archives, Historical Perspectives on Intimacy and the Law. Just to help situate you, we're streaming to YouTube and we are live from Fourth Space, and we are located here on unceded Indigenous lands in Tiohtià:ke, Montreal. And at Fourth Space, we work with our university community to help mobilize knowledge. We co-create daily activities, events, things that are happening across the university. Running today's event is a live stream Zoom meeting, and we have some panelists joining us there too, but also people joining us as guests. If you have any questions, you can pop those into the chat, and during the Q&A, we can read those out for you. Those of you here in the space, if you have questions later on, just raise your hand, and we'll bring a microphone over to you so that everyone can hear what's happening. Okay. With that, it's now my pleasure to hand it over to Director and Acquisitions Editor of Concordia University Press, Ryan Van Housty. Ryan, great to have you back.
Is the microphone? There we go. Thank you so much, Doug. Welcome, everyone. Thank you, Fourth Space, and thank you all for attending either in person or online. Concordia University Press is so pleased to be launching Family and Justice in the Archives, Historical Perspectives on Intimacy and the Law, edited by Peter Gossage and Lisa Moore right over here. I'm happy and shameless as well to say that we have copies that are on sale here for a rather generous discount. But I want to first talk about the book. This collection is brimming with expert analysis by skilled historians at various career stages. What is so impressive about this work is how the contributors use legal history and law documents to mine them, to conduct social history. The contributors to this book employ a range of methods to better understand the often hidden details of people's lives and learn how vulnerable people use the law, often as a last resort, in order to address systemic imbalances of power. Throughout, topics such as citizenship and revoked citizenship, racialization, inheritance, parental abuse, child emancipation, bigamy, and sex work are studied in specific times and places. What has always struck me about this collection is how the historians in this volume negotiate these troubling topics in respectful ways that help to show how historical inquiry into life's most traumatic events can be done so in both ethical and informative ways. So while much of this book is anchored in Canada, many chapters are also international in focus. The expanded understanding of what constitutes intimacy is also an illuminating theme developed throughout this work to open up connections across continents and centuries. We are delighted to have our volume editors with us today, as well as a number of the contributors, in order to have a much more detailed discussion of some of the topics and themes I've just alluded to. In a moment, I am going to hand the microphone over to our moderator, Eric Reiter. Thank you, Eric. But first, I would like to just take a moment to thank Peter Gossage and Lisa Moore for working with us and publishing this exceptional group of essays with Concordia University Press. Please join me in a round of applause for Peter, Lisa, and all our contributors. Thank you. So I'm going to hand it over to Eric, who's going to moderate a discussion. Eric is a professor in the Department of History here at Concordia University and the author of a relatively recent book, Wounded Feelings, Litigating Emotions in Quebec, 1870 to 1920, which was published by the University of Toronto Press and the Osgood Society for Canadian Legal History. Thank you all.
Thank you, Ryan, and bienvenue à tous. Friends, colleagues, collaborators, glad to see you all here. So it's my pleasure to introduce the panelists that we have today and then to get things started. And I will mostly turn the floor over to them and let them explain to you about their contributions in the book. So very briefly, I think you know our two editors. Peter Gossage is a professor of history here at Concordia. Lisa Moore is a doctoral candidate in history, soon to finish her PhD. So I'll introduce our panelists. We have four panelists, roundtable participants here today. So Riyad Sadiq Koya is in the upper left on Zoom, who's a PhD candidate in history, Indian history and Indian diaspora, if I'm not mischaracterizing your research, and he's working at University of California, Berkeley. Wandrea Bates is also on Zoom, lower right, is a professor in Latin American history at Winona State University in Minnesota. And Gail Savage, also on Zoom, is a professor emerita in British history at St. Mary's College of Maryland. And with us here in the studio is Jane Nicholas, who's a professor of Canadian history at St. Jerome's University, Waterloo, Ontario. Now, if there are any other authors present on Zoom, I can't see who's on Zoom, please let us know. And I see, je vois des auteurs dans l'auditoire ici. Please let us know and join in the discussion afterwards if you are here, because we'd like to hear from as many of you as possible. So the roundtable. Questions were circulated to the panelists, and they were invited to answer any, all, or none of the questions. So I'll just put out the questions, and then they can choose to ignore them or not as they see fit. So the first question was the challenges and rewards of exploring intimacies through legal institutions and records. So the idea of intimacy. Second are the ethical challenges of studying ordinary people in times of vulnerability, pain, or violence in confrontation with the law, so ethics. And then the third is using individual case studies that are grounded in the local to explore broader themes of this international and comparative project, so case studies. So I will turn it over to the panelists to get us started on these issues, and then afterwards we can open it to the audience, both real and virtual, to continue the discussion. So the panelists have about 5 minutes or so each, and we'll hear from them in the order that they appear in the volume. So Riyad Koya first, followed by Wandrea Bates, then Gail Savage, and finally Jane Nicholas here.
Eric,
oh, sorry. What was I supposed to do?
there were some preliminary remarks in
oh, right, okay.
Myself, and not to, you know, I mean, I'm anxious to hear Riyad, and but shall I just jump in? And
sorry about that, Peter.
Yeah,
yes,
yeah.
I skipped over something on my ordre du jour here. So,
so thanks, Eric, for that, for those remarks, and for agreeing to do this panel with us. So Family and Justice in the Archives, as the subtitle suggests, presents a range of historical perspectives on intimacy in the law. It's a collection of 16 essays that explore legal archives as a window into familial, domestic, and sexual intimacies on 5 continents over a span of 2 centuries. Each chapter represents, as Ryan mentioned, a deep dive into a specific topic in a particular time and place. So this might be inheritance practices on indigenous reserves. It might be criminal prosecutions for bigamy or infanticide, guardianship arrangements for orphaned children, or debates over marriage and citizenship during the global wars of the 20th century, just to name those few. But they're also tied together by some universal themes and questions, and by a shared methodology that seeks to locate these, I'm going to use air quotes here, private matters in the archival traces left to us by very, quote, public institutions associated with the state and with its legal and judicial systems. And as Ryan pointed out, this is social history using legal sources, and there are both challenges and opportunities associated with that approach, as Lisa and I tried to point out a little bit in our introduction, and as I'm sure we'll see in the discussion today. All of these essays were originally presented at an international symposium here at Concordia, organized by Eric and myself in May 2019, with a lot of assistance from people in the room, including students. And when we invited our contributing author, Gail Savage, to participate in today's launch, she made a comment about that pre-pandemic gathering, didn't you, Gail, that has kind of stuck with me. And I hope she won't mind me quoting her here. And she said, "The conference was such a great experience that any way to recapture that atmosphere of exciting scholarly interchange would be wonderful." And so that's the hope we have for today's launch event, and especially this roundtable discussion, which was proposed to us by the press and which we embraced wholeheartedly. 5 ans après ce colloque, par ailleurs, je suis content de voir des visages dans la salle et à l'écran de personnes qui ont participé aux échanges à cette époque et qui ont le goût de les poursuivre avec nous cet après-midi. Alors, merci à tous et à toutes de votre présence, de votre intérêt, de vos contributions et de votre fidélité. And so with those, I hope, brief preliminary remarks done, I still want to talk a little bit about some things under the heading thanks and acknowledgements. So here I go. I want to begin by saying that I'm especially grateful to my peerless co-editor, Lisa Moore, who is a talented emerging scholar of youth culture and juvenile justice. Lisa has the perfect skill set for projects like this, blending intellectual rigor, and she's blushing, with the ability to stay organized and some key people skills like patience and kindness. So I'm expecting great things, Lisa, looking forward to your dissertation defense in 2025. I'd also like to thank Eric, who has taught me a lot about the law, especially Quebec civil law, since I arrived at Concordia, and was a co-investigator along with Thierry Newtons and Don Fison in a SSHRC-funded research project that led to the symposium that led in turn to this published volume. Merci aux collègues, aux étudiants et au personnel administratif du département d'histoire de l'Université Concordia qui m'offrent au jour le jour un environnement intellectuel stimulant et progressiste, tout comme mes collègues au sein de 2 réseaux de recherche québécois, à savoir le Centre d'histoire des régulations sociales et le Centre interuniversitaire d'études québécoises. Merci à vous tous et toutes. We receive financial support for the symposium for both these organizations, grants from SSHRC and from Concordia University, and for the volume, we had contributions from the Federation for the Humanities and Social Sciences and from Concordia's ARRE program, which is Aid to Research-Related Events, Exhibition, Publication, and Dissemination Activities, which is too long to fit under the acronym ARRE, but anyway, they kept it. We're very pleased, of course, to work with Concordia University Press, who are the new kids on the block in the area of Canadian academic publishing, and if this is not mixing a metaphor, who are already punching well above their weight. I guess you can punch when you're a kid on the block, right? Thanks especially to Ryan, who was the new acquisitions editor when we first pitched this project and who has been enthusiastic about it from the very beginning. Thanks as well to Salen Tourdy, who did double duty as project coordinator and copy editor, Meredith Carruthers, and everyone else at the press who has worked behind the scenes to bring this new book into the world. And we are grateful to the press and to the folks at Fourth Space for hosting today's celebration, and to the Department of History for kicking in for drinks and snacks. J'aimerais par ailleurs profiter de l'occasion pour remercier Stephen Watt pour son travail impeccable dans la traduction de 3 de nos chapitres présentés en français lors de notre colloque international et bilingue. And although Lisa and I have our names on the cover, all of the credit for the wealth of original insights, analysis, and interpretation in this volume really does go to our wonderfully talented and generous contributing authors who are represented on the panel today by Riyadh, Andrea, Gail, and Jane, and who are represented in the audience by Isabelle Bouchard. I don't know if Chandra Murdoch is checking in on Zoom, but if she is, thank you. Anybody else I've forgotten, thanks very much. We've thanked them very many times on email, but it's my great pleasure and privilege to do so publicly and most sincerely this afternoon. I'm almost done. Lisa and I chose to dedicate this volume to our families, by which, of course, we meant the people we love and with whom we share our daily struggles and achievements. I'll let Lisa talk about Corey, Owen, and baby Grace, and I challenge her to do so with a dry eye. But for me, this means my amazing wife and life partner, Anne-Marie, who is either in the room or on the way from a lecture she's giving at McGill on hospital architecture, as is often the case. It also means our wonderful children, Charlie, who I know is checking in on Zoom, an aspiring filmmaker in Toronto, and Katie, who is living her dream of a dance life and teaching a class as we speak, also in Toronto. But we also meant this double plural, our families, to embrace broader notions of family that include extended networks of Moors, Gossages, and affiliated kin, meaning our loving and supporting siblings, parents, in-laws, nieces, nephews, cousins, and in my case, our kids' partners, Salut Mathilde, and so on. And in addition to our contributors, in addition to that, I would also mention, that plural our contributors' families in all their wonderful diversity, including chosen families of intimate friends, collaborators, and so on in various configurations. And we're also, and I really will finish here, indebted to the dozens or perhaps hundreds of historic families and individuals whose intimate experiences, filtered through the dusty or digitized records produced by judicial and other state-sanctioned legal processes, form the documentary bedrock of this collection. So while they are not, strictly speaking, our families, we dedicate this volume to them as well. And there she is. Hi, Anne-Marie. Thank you very much. I'll pass it over to Lisa.
Thanks, Peter. I don't want to be too repetitive. I think Peter covered all of our thank yous, but I would like to echo Peter's gratitude to our 18 wonderful contributors. They really were such a delight to work with, and I'm sure I speak for Peter as well when I say that they made our jobs as editors easy thanks to their excellent scholarship and their very consistent and generous collaboration. So I think we owe them a great debt for making this collection such a success. I'd also like to thank or give a special thanks to Ryan and to Salen and everyone at Concordia University Press, who expertly guided us through the entire publication process, and for doing so with plenty of encouragement and enthusiasm at every stage. My thanks as well to everyone in the history department, not only as a student there, but also for helping us out with this collection. In particular, Eric Reiter, who was a leading member of the research project that led to this volume, and who provided us with invaluable advice as we were writing the introduction for this collection and on numerous other occasions. One of the things I think sets this collection apart is the many opportunities it has provided for the involvement of students and emerging scholars. We're very happy that our collection includes contributions, for example, from postdoctoral fellow Chandra Murdoch, PhD candidate Riyad Koya, and from recent university graduates Emma Chilton and Emily Lord. And as Peter mentioned, this project was first conceptualized following the International Symposium, Family and Justice in the Archives, Histories of Intimacy in Transnational Perspective, which was held at Concordia in 2019, and which was supported by a really great student organizing committee that included my fellow grad students, Leslie Szabo and Paul D'Amboise, as well as postdoc Sophie Doucette. They played a really key role in the planning process, from corresponding with panelists to helping structure the conference program and organizing the event space, really making sure that everything went off without a hitch. So thanks very much to them for all their hard work. And something that Peter didn't mention was, this collection was the result of a SSHRC-funded research project titled Famille, Droit et Justice au Québec, which involved the work of 9 student research assistants from Concordia University, Université Laval, and Université du Québec à Trois-Rivières, who combed the judicial archives in Montreal, Quebec, and Trois-Rivières for several years for civil suits related to family disputes. And the research they conducted was really critical in leading the symposium organizers to come up with the idea that framing legal archives as a privileged window onto the intimate lives of Quebec families in the 19th and early 20th centuries could be placed into conversation with scholars and projects using similar sources in other contexts and in other time periods. So our heartfelt thanks to them as well. I was lucky enough to participate in the research project and symposium that led to this collection, first as an MA student and later as a PhD student. And I'm really grateful to both Peter and to Eric for giving me the opportunity to play an active and continuous role as the project evolved over several years, I think almost a decade now, since we started that. It has also been such a privilege to be co-editor of this volume, which I really must emphasize is a one-of-a-kind opportunity for a PhD candidate. And so I really owe my sincerest thanks to Peter for trusting me to lead this project with him, and for the invaluable mentorship and support he has provided me for over a decade now as both my MA and PhD supervisor. So thanks very much, Peter. As Peter mentioned, this book is dedicated to families, both the ones who emerge from the various archival records employed by our contributors, as well as to our own. So I'd like to take this opportunity to thank my family and friends, my brother, my sister-in-law, my niece and nephew, and especially my parents for their unconditional love and constant encouragement. And I'm going to try not to cry. And I'm most grateful to my husband, Corey, who has been my greatest supporter, and to my little ones, Owen and Grace, for bringing so much love, laughter, and joy to my life. I'll stop there, and I'll hand things over now to our moderator, Eric Reiter, to kick off our roundtable discussion.
So, now I'll introduce the roundtable. And I think we have to add a new question or a new point, is the emotions of family life, which are in strong evidence here around our round table, which is not round. So just a reminder of the three questions, and then I'll turn it over to our panelists. Intimacy. What are the challenges and rewards of exploring intimacy? The ethics of dealing with people in times of vulnerability through the legal archives, and then case studies. The rewards of the grounding in the local in a project that is explicitly international and comparative. So around 5 minutes each, and I hope that you can talk to each other as well as presenting your own ideas. And I'll start with Riyadh.
Thank you so much, and bonjour to all. It's a great pleasure to join you from sunny California. My thanks to Lisa Moore and to Peter Gossage for inviting me to join this forum today and to speak briefly about my contribution to the volume. My chapter considers a series of cases involving what would become known as the crime of wife murder. During the course of the 19th century, the Indian indentured labor system achieved considerable notoriety for this crime. Writing on British Guyana, Gayutra Bahadur notes that such murders seized the public imagination by the 1860s. Colonial newspapers played a prominent role in testifying to the barbarity of a crime thought to have been derived from Indian custom. Custom encompassed a range of practices reported in wife murder cases, including sexual jealousy, by which Indian husbands murdered wives seduced by other men. In response to rampant sexual violence on colonial plantations, officials embarked on what Prabhu Mohapatra has described as a campaign to restore the family. Officials across the indentured world enacted new laws to legalize marriages between heathen immigrants. Significantly, these laws instituted criminal penalties for the seduction or enticement of Indian women, reinforcing the conjugal rights of Indian husbands over their wives. The cases I explore in my contribution precede the campaign to restore the family. I note growing concern among Mauritian officials about the crime of murder falling upon a series of cases at the Mauritius Court of Assize in 1847 and 1848. Many of these cases involved the murder of Indian women by Indian men, although not all of them involved disputes between husbands and wives. Importantly, these cases involved a sentence of capital punishment. Colonial regulations mandated that such cases be reported to the Colonial Office. Consequently, court transcripts and other legal documents were sent to London under the cover of a dispatch from the Mauritian governor. The cases I discuss also precede legal reforms in the 1850s that displaced the French law of the colony. French law had shaped the prosecution and testimony of Indian immigrants. Megan Vaughan has argued that French legal records are a particularly valuable resource for the study of slavery, which had existed in Mauritius in the 18th century. They also offer snippets of speech from enslaved persons, though these fragmentary utterances are subject to incomprehension and mistranslation. The series of cases that I examine are no less subject to the vagaries of translation and interpretation. Nevertheless, I've examined these cases to understand how they speak to questions of family, intimacy, and the dispensation of justice at a particular moment of legal pluralism in Mauritius. To be sure, the speech contextualized within the case file is largely that of men. As Vaughan argues, the goal of criminal procedure was to uncover the truth of the crime, the existence or non-existence of intent, and the nature of that intent. Such intent was best captured through the testimony of the accused. In these final years prior to the introduction of the jury trial to Mauritius, we can see the crucial role of the juge d'instruction in securing testimony, if not a confession, confirming the intent or malice aforethought of the accused. Court transcripts suggest very little about how that testimony is secured. The testimony is read into the transcript as an already completed statement. One might infer a language game of question and answer from such testimony. Whether the resultant statements are paraphrased or quoted by the juge d'instruction remains ambiguous. However, we might glean further insights about family and intimacy from witness statements. I open my chapter with the testimony of Carpaille. To confirm her capacity to testify, Carpaille is asked to describe the marriage of her daughter to establish whether she is the mother-in-law of the accused, Virapatram. The court ultimately finds her testimony wanting. The marriage is described as not good. It is not legal. Her testimony against Virapatram is allowed to proceed. Her statement, though brief, is illuminating. First, she describes a marriage ceremony, which involves the presentation of a necklace to her daughter. This gift, made publicly at a banquet, binds the marriage. Carpaille makes a further claim in her testimony. In her telling, her daughter's marriage appears to have dissolved when Virapatram loses his position as Sirdar on the plantation. Mother and daughter take up residence with the new Sirdar, who Carpaille then recognizes as her son-in-law. Carpaille articulates a form of temporary marriage based on maintenance, and intimacy bound by a form of care. This is not Christian marriage. For colonial officials, the impermanence of the bond described by Carpaille resembles cohabitation, or, as Marina Carter notes, prostitution. Marriage laws adopted by Mauritius in the 1850s articulated a different form and conception of marriage based on conjugal right, anticipating the later reforms in the Caribbean to restore the family. In recent years, the archive of indenture has been expanded by scholars such as Bahadur and Ashutosh Kumar, who examine poetry, songs, letters, oral histories, and other vernacular sources to craft new histories of indenture that gesture more fully to the individual lives of bonded laborers. Court records can offer an important supplement to the vernacular archive. They offer what Ninka Boer terms speculative glimpses of subjectivity and bondage, a fragment of the life worlds of the enslaved, the indentured, the unfree. However, such testimony is marked by a scene of violence and murder. Witnesses are asked to revisit, to reenact the scene of violence in order to confirm the intention of the accused. Such testimonies inflected with trauma are largely unacknowledged by court proceedings. How we revisit and reenact these scenes of violence and trauma in our historical narratives has posed difficult questions for myself and other contributors, both at the conference and in the present volume. Perhaps those difficulties might inform further conversation. Thank you.
Thank you very much for getting us started. So I'll turn it over to Wandrea Bates.
Hi, everyone. I wanted to start by thanking Peter and Lisa so much. Thank you for getting this project started, and thank you for shepherding us all very generously and very patiently through this process. It has been an absolute pleasure to work with both of you. So my chapter opens with the story of two sisters, Maria Elena and Anna Maria Galuzzi. Maria Elena is 19, her little sister is 16, and they love each other and they hate their dad. They have a lot of reasons to hate their dad. Their dad, Ernesto, had abandoned the two girls when when Maria Elena was just 9 and Anna Maria was just 6 with their disabled mother. They describe a childhood filled of abject poverty where they survived on bread for weeks at a time. Ernesto came back when the girls were in their mid-teens. And when he moved back in with them and their mother, he had no job, but he did have a mistress. And he moved them into the house. The two girls by that point had found profitable work at a glass factory, and he moved back in. And they said his only contribution to the household was the fits and slaps and abuse of their disabled mother. The girls then describe in court that Ernesto forced their mother to live with his mistress up until the time that the woman died. And they described this feeling of abject shame that their mother had in the final months of her life. The two girls' story and their words come to us through Buenos Aires's civil court records. The two girls came to court and they filed a petition asking to be freed of the guardianship of their father. And although they describe these horrible abuses against their mother and Ernesto's abandonment, it wasn't the abuse and it wasn't the abandonment that was the subject of the real complaint of their civil court petition. Instead, it was the fact that he was stealing their money, that he was confiscating their wages, that he was calling upon this idea of patria potestad, this idea that fathers have the legal and civil control over their children. He was using that in order to claim their wages. Ernesto was probably surprised that his daughters filed this suit, and he was probably a lot more surprised by how successful they were. Because in Argentina in the late 19th century, fathers had absolute civil and legal control over their wives and their dependent children. So it would have come as a surprise to Ernesto that his two daughters were able to file this petition. And then when legal officials and social welfare reformers came to their aid to speak about the good character of the daughters and then to condemn the father, it might have been surprising to Ernesto when in fact the two girls were successful and they were able to leave their father's household and they went to live with an aunt. I read this story, and then I read hundreds of other stories of young people in turn of the century Buenos Aires who brought petitions against their parents to civil court. This is the subject of my chapter here. And so what I found in these very intimate descriptions of people's lives lodged in legal sources were a number of the things that I think kind of unite this collection. And so on one hand, young people frequently describe their everyday lives, what it was like to go to work. Frequently, they describe leisure activities. They describe being young in a city that is undergoing profound transformation during the last part of the 19th century and the early part of the 20th century. Argentina goes from a country that has a population of, Buenos Aires has a population of less than 150,000 people in 1889. And then by 1914, it has 1.5 million people. It is a burgeoning metropolis that is filled with amusement parks and shopping and trams that will take you across town and a really cool zoo where young people are always going. So you see young people that are describing a really exciting new world that they live in. And then you also see abuse and poverty and struggle within the same sources. And so what I was really interested in my chapter was I was really interested in kind of recreating this everyday life of young people, but then also trying to understand their values that they brought to the courts when they were filing petitions against their parents. And I think that really right there is, for me, what is the incredible benefit of histories of intimacy. When I first started this project, I would have very much described myself as a historian of family. And then you would have, 5 years ago, I would have been spending a lot of time asking you questions that were like, does this count as family? Does this relationship family? How do we classify this? And I think that what intimacy as a category of analysis really allows us to do is, instead of imposing our notions of who is valuable, what relationships are valuable in the past, is really to try to listen to, in a genuine way, our historical actors. So in my case, I started with the story of two sisters, and there's not as much literature surrounding sibling relationships in the past as there are about sexual relationships or relationships between parents and children. But in looking at relationships of intimacy rather than in traditional lines of analysis of sexuality or parent and child, in looking at relationships of intimacy, what that allowed me to do is it really freed me up to take the relationships that many young people were articulating as very valuable to them, the relationships between siblings, to take that seriously. And so in that way, it really allowed me an avenue into a much richer world of not only social relationships and not only emotional relationships, but also economic ties that are really important in the world of young people in Buenos Aires. And so then in thinking about connections that I think intimacy, the category of intimacy allows us to explore, is that in addition to taking these people who are defined as really important, it also allows us to look at what historical actors deem as important when they're bringing up legislation or when they're bringing cases before courts. Because frequently what in the literature that I had seen, if I had just taken the literature that had been produced before me, I would have been really looking at just like relationships of just tensions between parents and children. But when we take the category of intimacy, what we can see is that young people are frequently defining what's really important to them in different ways, particularly in ways that are focused on economics, in ways that are focusing on the ability to have autonomy in movement, particularly surrounding migration and both internationally and domestically. And so I think that in taking that seriously, what we then are able to do with intimacy is we're able to connect that incredibly personal relationships with really macro historical processes in a way that we might not otherwise be able to do. So I think those are the two benefits that I see as really coming out of this study of intimacy. And that for me really is the joy of the micro-historical approaches that many people take in this collection. So I think that by the study of family and intimacy and law, there's this incredible benefit. It's like you can zoom in. It's like, remember when all of us abandoned PowerPoint and we went to Prezi? Maybe some of you are still using Prezi, but for me, that was like a really intense hour and a half. But it was like you could have that big bubble and then you could zoom in very specifically on things. And I think that this is the joy of this collection, right? Is that these micro historical approaches, like they really allow us to simultaneously track out macro historical forces, to do a comparison and contrast of how those are interacting across the globe, both how they're similar and different, but also how they link to one another. We can start to trace out how legal systems impact each other, and that we can do that while taking seriously what our historical actors value the most, like what the things about how they love, how they survive, how they struggle, how they figure out what it means to be human in shifting historical contexts. And for me, that really is the heart of the ethics of studying people in times of conflict, is really to listen to our sources and to really interrogate our sources very critically, to think about what people could say, and to think about the different motivations between the alliances that people are making inside and outside of the courtroom. And instead of imposing our own labels on them, to really value the way that people are interacting with each other, the way that people are forming relationship, and then the way that people are surviving in the past. So I can't wait to talk to the rest of the panelists.
Eric, can I say just one thing?
Yeah.
I'm going to switch from PowerPoint to Prezi tomorrow. So just for all those benefits, Wandria.
Well, I think it's really, even having just heard two of the roundtables, we're starting to see the points of contact and unity in this very rich collection of papers. So I think there's going to be a lot to talk about when we open up the roundtable. But now let's turn it over to Gail Savage.
Okay. my chapter dealt with the problem the British government faced in the closing months of World War II when British servicemen began to return home from the Eastern Front, accompanied by wives who were Soviet citizens. This happened in two fronts. It happened in Moscow, where British people and Soviet people interacted. And it also happened in the frontiers of Ukraine, where British POWs found themselves freed, but not supervised by the Soviet army as they progressed their way west. Now, what happened, what ensued, is a conflict at one level, the highest level, was a conflict between British authorities and Soviet authorities over the status of the women who British men had married. Under British law, a British man who married a foreign woman, the foreign woman became a British subject. Under Soviet law, a Soviet woman who married a foreigner remained a Soviet subject. So the British treated these women as British subjects who could be repatriated, so to speak, to Britain, and the Soviets treated them as Soviet subjects who were not permitted to leave the Soviet Union. And so there ensued a conflict over whether or not the Soviets would give permission for these women to leave. And in some cases, such permission was given, and in other cases, it was refused. Now, I explored this through the vehicle of Foreign Office records, which are not quite legal records, but they were quite detailed about individual cases. And what you see in looking at the records of the individual cases, I think, is the way in which individuals in quite extreme circumstances would construct their own lives or attempt to construct their own lives. So the records would reveal, at one level, the norms of the authorities, in this case, two authorities who were at odds with one another. It would also reveal the norms expressed by the behavior and the words of the people who were subject to those authorities. And in addition, it would show either resistance to those authorities, or actually there could be some combination, resistance to those authorities, or the utilization of their norms to achieve the ends that the individual sought to achieve. Another thing that came through with these cases, was that people were not always reliable reporters to authorities. And sometimes, as these cases unfolded, it was revealed that the marriages had not taken place or the marriages were not legal, and that there were ulterior motives on the part of the individuals at the individual level. So that it seems to me exploring intimacies in history are revelatory of norms and authority and the resistance or to the utilization of such norms on behalf of ordinary people, or that ordinary people utilize these on their own behalf. And sometimes authorities were quite baffled at the behavior of the particular people who were caught up in these sometimes rather dire circumstances. At one level, then, this is a story of the Cold War as relationships between the Allies, the Western Allies on the one hand, and the Soviet authorities on the other, deteriorated at the end of World War II. And you can see that in the language employed by authorities, where they complained that they thought they were allies with the Soviets, but surely the Soviets would not treat their allies in such a way by interfering with family formation on the part of ordinary people. So there was a profound misunderstanding or talking past one another going on at the highest level. At the much lower level, you had people telling their truths as they saw them, which did not always conform to the view of truth on the part of the authorities themselves. So, so anyway, I think this actually conforms quite a lot, or parallels quite a lot with what Girandra was talking about in her cases. I wanted to bring up one issue when in dealing with the ethical challenges. I think that this kind of approach to the past is important for creating a humane understanding of the ordinary person as you delve into these cases, so that even if people behave in quite in ways that don't conform to our own expectations or the expectations of authorities in the past, you have the human dilemmas that these people confront and the different ways in which people try to deal with those dilemmas, which I think, as you tell those stories, create a space in which people can be even more sympathetic with one another. There is another kind of ethical challenge that I just want to raise that I have encountered in doing research, and that is the ethical challenges that are mounted by people who have an interest in preserving privacy, the privacy of people of the past. Do we reveal the full names of the people we discuss or not? Are these records to be made available to us as historians when they treat the intimate lives of the people involved in these disagreements or legal conflicts? During my lifetime as a researcher, I have spent a lot of time researching divorce and records in England, and those records have gone from a 75-year mandatory closure to being totally open from the moment of their creation. So there was a time when you couldn't use them at all, at least not unless 75 years had passed from the last legal action, and legal actions could unfold over many years. And then there's also the case of archival collections that will deny access to the archives unless one agrees to suppress the names of the people involved. This is sometimes not hard to do. I mean, you can substitute letters or numbers or some kind of shortened form of name. So I'm not entirely sure that I have a fully developed idea about this issue, except that I have noticed that insistence upon privacy is often something that you can't achieve anyway, because a lot of these cases are covered in the press. And so you could, the archive could say you can't discuss this material unless you don't use names, but then in the newspapers, of course, the newspapers have the names. So there are lots of cases in which the materials cannot be fully privatized because no one has total control over the materials relevant to the case. Some things are quite open and other things may be withheld. So I just want to raise that as a question, especially since I don't know the answer to the question. And I think that about does it for my treatment of these issues.
Thank you. We're getting the makings of quite a conversation on issues of intimacy, on scholarly practice, on other aspects. So I'll ask our last roundtable participant to contribute. Jane.
Thank you. I just wanted to start by echoing what other people have said about what a pleasure it's been to work on this project, to work with Peter and Lisa and everyone at Concordia University Press. And Eric, from the early days in the conference, it's just been such a highlight. And I actually had the opportunity to work with Peter and Lisa once before. And so when this opportunity came up, I leapt on it because it was just such a good experience to work with both of you. So thank you. You're brilliant editors. My chapter in this collection is on a really grim subject of incest and infanticide. So I'm not going to speak to it specifically, And instead, maybe I'll talk about what I see as the benefits of the way Peter and Lisa have framed this collection around intimacy. Because intimacy as an analytic is so broad and expansive, it allows us to read into single case files any number or range of relationships that are at once intimate and private and intimate and public. And one of the things I really appreciated about your introduction is you talk about how intimacy cuts through that dichotomy. And I think that's really important. And for me, intimacy allowed me to explore the irregularities in relationships, as well as the solidarities that emerged in the wake of those irregularities. And so relationships between sisters and brothers, and especially between mothers and daughters who worked really hard to mediate men's violence. And in the wake of that, when they failed to manage that violence, sometimes resorted to acts that would seem to be terribly cruel. And the thing I found really interesting in the case that I studied here was how that last act of cruelty that a woman did in the wake of, failing at managing someone's violence was the thing that brought her to court. But then seeing this violence in a bigger pattern. And I think there's also a terrible intimacy to violence, and allowing us to focus on intimacy allowed us to capture the fuller range of relationships that were at work. And of course, this brings up any number of ethical questions for historians, and I think all of us think through these things in a lot of detail, but we often do so alone and quietly and worry about it at our desks while we write. And I think a real strength of the collection is that Peter and Lisa gave us all time and space to work through it in writing, which, save for the oral historians who, talk about methodology and ethics a lot, many of us don't get the opportunity to do. So thank you to both of you for letting us do that. And to what Gail pointed out earlier is I think historians struggle with this because there is no right answer, but it is a struggle that you work through and you ask the questions of what's best given the archives you're working with and the cases that you have, and then try to come up with your own ethical practice around it. But for me, and I think this is another strength of the collection, is just how the authors have managed to thread the line of really getting into detail without turning it into sort of a sensation. And sometimes I do wonder about the rise of interest in things like true crime and how that might impact us as historians and how we write and in how we wish to present our cases. But this was all under Peter and Lisa's guidance, so it's all to you.
So I guess before opening it to the audience, I wonder if the panelists would like to respond to each other. And that includes Peter and Lisa as panelists as well. On any of the sort of cross-cutting issues that we've seen about intimacy, about ethics. Riyadh brought in issues of language and translation that I think come up in all of our work. So I wonder if you had any comments on each other.
I can say a little something about naming, which Gail brought up. Indentured labor is quite different from slavery in that each laborer comes with an emigration pass that names that laborer. That's not necessarily true of many women who migrated outside of indenture, but eventually many do to colonies other than Mauritius, and they're also named, including members of my family to Fiji. So there's this kind of privileged lack of anonymity to studying the indentured laborer as opposed to that of the slave. And there's a funny way in which the border poses this question of the individual identity by having that immigration pass filled out before they embark upon the ship. And that pass is then used to trace intimate lives very successfully by Rena Carter in the case of Mauritius, as people marry and acquire property, and so on. And with indenture, there's the question of whether or not there is agency that is not supposed to inhere for a slave. So there's almost kind of a celebration of that agency and that individuality that now we may begin to question as we understand working with sources like capital cases where there's traumatic violence involved. So like the other panelists, I've been very much on the fence about naming, and I would definitely invite more conversation about that. And certainly different sources are going to lend us the capability to name, and that might be worth discussing as well.
I could just jump in there too. I mean, I was struck by a number of things that ran through everybody's interventions, everybody's comments, and made me remember what a rich collection this is, and how powerful so many of the pieces are, and how difficult in a lot of ways too. Incest, infanticide, femicide, and so on. But I'm thinking about Lisa's research and looking at young women caught up in the juvenile justice system in the 1950s, 60s, and 70s, and obviously to respect the privacy of those people, but I remember some of the hoops that you were jumping through to gain access to those records. So maybe you would like to talk about that. The other thing that struck me as a kind of through line was legal pluralisms of different kinds, because I've always loved that we have this chapter, Riyadh's chapter on Mauritius, and we have Isabelle's chapter and Jean-Philippe Garneau's chapter on Lower Canada, and looking at these colonial situations where there was a French regime and then a British regime, and seeing how things emerge quite differently in both places, thinking about a French system of criminal law that persisted into the British regime, if I've got that right, if I'm remembering right, Riyadh. But yeah, and then Juandria talking about patria potestad, sorry for my Spanish pronunciation, but of course, puissance paternelle in Quebec civil law, it sounds like exactly the same kind of thing. So that kind of Spanish-derived civil law sounds quite similar to me to French-derived civil law. And then, of course, with Gail, this complete clash of legal cultures between Britain and the Soviet Union, and sort of contesting what's a marriage, what isn't, who's a citizen, who isn't. So that's another kind of area where I thought, I was hearing a lot of, resonances when I was listening. But if I may, I could pass it over to Lisa, if you don't mind talking about your research a little bit and privacy issues. Naming.
Yeah, it's interesting to hear both Juandria and Gail bring up, issues of minors in Juandria's work. And I'd be interested to know what you think about the idea of naming, or the issue of naming. And then Gail talking about this idea that a lot of these cases would have been public in newspapers, or in, just out in public in general. These people would have been named. And so how do you work with archives when, names are already out there, and why are you restricted in certain ways? So for me, it's been such a black and white issue, because working with minors, and I don't know if this is Juandria's experience as well, there's such a strict limitation on how you can present them. And it's not just naming, it's also making sure that you don't, include any kind of markers, biographical markers, addresses, any of those kinds of things that could, potentially allow someone to discover who you're studying or who you're talking about, especially in the post-war era as well. So, Gail talked about this 75-year limit, and in my own research, I've had to get permission from a youth court judge to actually even look at these records. I'm not allowed to take pictures or any of that sort of thing. So I think it's interesting because it shows how time, the passage of time, can affect this, who you're studying. So minors versus adults, yeah, I don't know if Gail or Wandry want to speak to that, but.
Yeah, Gail?
Okay. Well, one thing I wanted to mention is that in my work on World War II and immediate post-World War II transnational marriages, where I did use the names that were recorded in the records. Of course, these are adults. But sometimes I'm dealing with issues of illegitimacy of children and bigamy, some very fraught issues. But one of my experiences has been I have been contacted by the children of such couples who were extremely gratified that I had written about this because it was a window into their own experience growing up, and it was revelatory of the experience of their parents that they were not privy to. And so it expanded their knowledge of their own origins. And I've never been contacted by somebody who was angry with me or upset at something that was revealed. Now, that doesn't mean that couldn't happen, but it certainly hasn't happened yet. And my experience has been exactly the opposite. So I think there is an important concern about the negative impact of revealing names or revealing details. And I'm not so sure that people have thought about the positive impacts that it has potentially, revealing a past to people who don't have access to their own past. So I just wanted to add that in.
Yeah, I wonder if Jane or Wandria wants to come in on that. When you start going back 3, 4 or more generations, do the questions change or not really?
All I want to do is hang out with Lisa and kind of like swap war stories about getting into the archives of minors. My getting into an archive is like one of my top 5 life stories. And so in Argentina, I had done this exploratory project, or I'd done this exploratory trip to the archives, and I just figured out this way to get 5 names to see if I could get into accessing these custody disputes. And so when I did that in my year-long research trip, they were like, yes, here are these 5 cases. But when I got there and I had a few hundred names, they like figured out, like, I don't think this lady is related to like these 500 people. And so then they were like, no, you cannot see these records unless you get permission from the judge who oversaw the case to see these records. But my cases are all between 1871 and 1922. And so those judges are like not dead, they're like very dead. And so it was very difficult to get their permission. So then there was this whole system that was built around it that was like, okay, well, you have to petition the person who took over their files to get permission to get into this archive. So I just kept coming back over and over. Like, I'm wasting my fellowship year in Argentina coming back to the archives over and over and asking to get into these archives until eventually I'm just like standing there just being incredibly frustrated. And then it's the basement of the Supreme Court, and a guy comes over to me, and of course he's smoking a cigarette because he's smoking a cigarette in the like right next to these archival records. And then he's just like, why are you always here but you're never doing anything? And then I was like, oh, I would really like to be doing something. I would really like to be in these archives looking at these records. And he was like, oh, well, just come with me, you can sit at my desk. And so then that's how I got access to my records. So a less bureaucratic process, Lisa, I think, than yours. And in that way, the decision of whether or not to name people was left entirely up to me. So there's not like a standard protocol, because I'm still waiting for the return response from those judges, those dead judges. So I don't have a standard protocol for what to do. And so it's something that I've thought a lot about thinking about Gail's point of like, these are stories that are sometimes in the newspapers. So for my stories, my cases, these are not stories that are in the newspapers. They're specifically not stories that are in the newspaper. And some of the stories, some of my records are about young people that sue their parents, and then others are people who have had children that have been ripped away from them by the state, or that have had ripped away from them by other family members who never have their stories told. And so I think, thinking both to Riyadh's point of the privilege of being named, that some people, the horrific violence that is done to them and their family in taking away their children without so much as a judicial procedure, often just for being poor, or from, the case of Argentina, being a migrant from the interior, those are stories that never are told, that are never put into the record of the newspaper. And so in some ways, I think about it a lot, this balance between respecting people's privacies and then also having their stories told, that there is a historical record of what they have done and what has been done to them. And so I think the tension there for me is very present. It's a very serious issue of whether or not to give the names. In my case, what I frequently do is to reference the court cases by the way that they're written in the archives, which conveniently often obscure the names of the people that are involved because of the notation systems in the archives. But I think this is like a real ethical issue that I'm really happy that we're all discussing.
Yeah, just to pick up on a couple of points that were raised, like, I don't think more bureaucracy is the answer to our ethical quandaries. I think it is in conversation that we can come up with individual solutions, because I'm really aware of what the oral historians go through, and that's a terrific apparatus that they have to navigate, and I wouldn't want to see that for those of us using archival records unless, the archive or the law demands it. But I do think there's something to, and perhaps this is naive, but restoring the dignity to people by telling their stories in ways that helps to make sense of it for another generation, and in a way that brings the sort of wider context of their lives to bear in cases, especially where people were told they were personally responsible for something. Mm-hmm. And I would probably be more inclined to anonymize the people who were victims. But then do you anonymize the perpetrators as well? And in cases where there is intimate violence, you can't do both, right? And so again, I think it comes down to just working through these on a really individual basis. And one of the things that I really enjoyed in reading the book was that we all handled it differently, but in a way that made sense for the history and the archives that we were working with.
So maybe now's a good time to open the floor to the audience. I know that there are people on Zoom, and I think they can answer or ask questions in the chat. But those who are in the room, are there any contributions you'd like to make or questions you'd like to ask?
Yeah, so for those of you in the room, if you just want to raise a hand, we'll get a microphone to you. It's just so that those on Zoom can keep hearing and participate in the conversation. If you are on Zoom, you can feel free to type your question in the chat, or you may use the raise hand function. And when we call on you, you can turn on your video and microphone. So anyone in this space, if you have a question, just raise your hand. We actually have a question online. Chandra, if you want to start your video here, just one moment. We're going to bring you up on the big screen. Wonderful. Go ahead, Chandra.
Hi, so my name's Chandra Murdoch. I am one of the contributors, and so I also want to just take the chance to say thanks to Peter and Lisa and to the press and to everyone. I've really enjoying this conversation, and It's been such a pleasure to just sort of reread the collection and think about this question of intimacy, quite a while after writing this piece. But this question of anonymization and archives is very close to my piece and my work. I think I work on generally I work on Indigenous political response to the Indian Act in the 19th century and at this conference, and then subsequently I've looked at the question of inheritance. And so that sort of brought me into these really much more intimate relationships, and just sort of thinking through everybody's comments. Like, I think it's really important to sort of understand your archives, where they're coming from, and just sort of the intimate involvement of the state in certain people's lives, and how that generates very specific archives. So, if you're living on a reserve and you have an Indian agent who's monitoring your marriages, monitoring the legitimacy of your children, monitoring their ability to inherit those properties, it's a completely different type of archive that is generated from these legal structures that certain people are living under. So this is something I think about a lot. And so I don't know. Yeah, I think just in terms of taking it as on a case-by-case basis, like for me, the records that I work with in terms of organized political response on on inheritance, I feel very comfortable, using them. They're directly directed at the state about the law, but the questions of individual families, I decided to anonymize the people who are involved. But not just in terms of the names. Like, I think I was very conscious about not getting drawn into discussing the family conflicts that are present in these files. And instead, but those are often very interesting stories, they're very, very, dramatic in a way, but just to sort of always sort of try and train my narrative and train which archives I'm looking at to sort of trace this architecture of the law, that we can see people living through from that. So anyway, those are just some thoughts, and just to say thank you again to all the panelists, and to get a chance to think about the collection.
Just want to say thanks, Chandra. That was great.
Are there any questions from the audience? Barbara?
Thank you so much. I'm really looking forward to reading this volume. Barbara Lonskovsky from the History Department here at Concordia. I have one big question and a larger one. Who was this mysterious man with a cigarette, Drandra, who gave you access to the archives? A judge? A bureaucrat? Yeah, a security guard, perhaps?
It was an archivist, and then I just got to hang out with him and two other guys, and they would bring me tiny cups of coffee while I was reading my documents. It was a wonderful experience.
Okay.
If you're ever in Buenos Aires and you need a great cup of coffee, archives in the bottom of the Supreme Court, that's really where you want to go.
Thank you. I have been struck by how little we know about the history of siblings. These are some of our longest lasting relationships in our lives. These can be relationships of solidarity, people we can think of as allies, also people with whom we might be deeply estranged from. And so I'm wondering, in your various projects, and I can probably kind of see connections here with Jane and Lisa's research, your own research, might you be able to speak a little bit to this history of this relationship? Thank you.
Peter, you want to?
I can. Thanks, Barbara. I've done some work with Sophie Doucette, who was participating in the symposium and who did her PhD on a bourgeois family in Francophone Montreal, but who became very interested in siblings, and she taught me a lot about history of sibling relationships. And it's true what you say, we know our siblings longer than anyone else in our lives, longer than our parents, longer than our partners, longer than our children. So and it can be a fraught relationship. So what Sophie and I are doing together actually is working with a set of court records. They're mostly civil suits, and they come from the big project that I did with Eric and Don and Thierry, and with all the help from Lisa and others. But yeah, and what we're finding, we've given a couple of papers on that topic, and you see both the conflicts, which is what you kind of expect, but you also see solidarities. Sisters testifying on behalf of the other sister, and it was about 50-50, much to our surprise. You were really expecting to see conflicts over inheritance and that sort of thing, which we did find, but a lot of different forms of solidarity between siblings too. So there's so much more that can be done around siblings, and it's true that histories of intimacy, and I can't remember who framed it this way, but it is a nice way to get beyond history of the family. And there was Wandria, and where historians of the family as such didn't pay much attention to siblings for some odd reason, and more interested in parent-child relationships or in sexual domestic partnerships. But yeah, so maybe putting those things together, history of intimacy, history of siblings, but also, Sophie's very strong on history of the emotions. So to Eric's point, that's, you see a lot of that in court records as well, as Eric has shown so eloquently in his book. So, yeah.
Well, I'm conscious that we are getting to the point where we had decided to make this an informal conversation over some goodies and books for sale, of course. So I guess I will thank our panelists, thank those who Zoomed in, and unfortunately you can't partake in the goodies, but we hope to have conversations with you in person at some point. So there's lots to talk about. We've hit family, we've hit archives, we've hit history. Justice hasn't been mentioned. So maybe that's something we can, how does justice fit into this when we talk about things informally? So I think now is—
I'll just say one more thing and then
wrap it up?
Yeah, that's something that Eric challenged us to do in our introduction, that we had, family and justice in the archive.
And you did it.
Yeah, we had this long development on, family intimacy on the one hand, archives on the other, and where was that justice piece? Where is the history of the law and the legal system, and what did we mean by justice? Was it really justice what we were looking at, or was it a particular definition or understanding of justice? So yeah, I hope we rose to that challenge. The only other thing I wanted to say is that I know this event in this room goes until about 6. But we also have a reservation at McKibben's Irish Pub in the downstairs speakeasy pub, and everyone's invited to continue over there after things, or just go on home and have dinner. But thank you all for participating this afternoon. It's been great. So
thanks to our panelists. Yes.
Okay, thank you everyone. Thank you Peter and Lisa and Ryan. Thank you so much to all of the collaborators for coming into ForSpace, whether digitally or here, to activate this wonderful conversation. To everyone online and those of you in the space, thank you for your contributions and your questions as well. We're gonna be closing up this Zoom and live stream now, so thank you, goodbye collaborators, have a great evening. But just a quick reminder that this conversation is already available on our YouTube channel if you'd like to revisit or share it. So once again, thanks everyone. We love having you here. Go enjoy some snacks.